My name's Judge Bernard Skomal, and I'm a mediator and arbitrator at JAMS. Well, it seemed like a perfect fit to pursue ADR after my career as a magistrate judge and a criminal defense lawyer. As a criminal defense lawyer, I settled many of the most difficult cases. As a magistrate judge in the Southern District, our district has what's called an early neutral evaluation program. They are basically settlement conferences before case management conferences, and I had about 2 to 3 every week. So, having that experience, as well as having done numerous evidentiary hearings and bench trials, I thought it was a perfect fit for me to do mediations and arbitrations at JAMS. My mediation style tends to be evaluative. I'm a firm believer in what's called the 5 Ps. Prior preparation prevents poor performance. What really works is knowing your case and getting down to the nuts and bolts and educating the parties so that they have an understanding the risks they face if they go to trial versus settling today. When I prepare for an arbitration, the first thing I do is I look at the arbitration clause. If the arbitration clause gives me a certain scope, I know my authority, I know what I can do, what rules to follow, what law governs the arbitration, what my limits are. I then segue into what the complaint is, what the defenses are there counterclaims, to educate myself more importantly. But the arbitration clause is the first and most important thing I look at. The practice areas that interest me at JAMS for mediations and arbitrations are intellectual property. I do patent cases, copyright cases, trademark. I do lots of employment discrimination cases having to do with disability, sexual harassment, contract disputes of all types I deal with, and civil rights, wrongful arrests, excessive force cases, wrongful death cases. The most challenging aspects of mediation is when parties are unrealistic about their positions. A plaintiff will come in with an outrageous demand when the case is not worth that. Or I'll have defendant or insurance company nickeling and diming the plaintiff, hoping to basically get the case for free. I actually evaluate the case. I will break down a case into its elements, the facts, and the law, and then I will present the parties with open-ended but very telling questions to have the parties look at their case realistically. What are the strengths? What are the weaknesses? My goal is to bring the parties down to earth with an understanding of what their case is probably worth at trial, to bring the parties to a position where they will be realistic about their settlement proposals.